As you know, we are today to discuss criminal appeals, how the appeals are drafted and presented to the appellate courts, what is the procedure, what is the substantive part of this subject, and what are various facets, various problems relating to this subject, which a practicing lawyer has to face while preparing the appeal, while arguing the appeal, and what is the role of appellate court in dealing with an appeal preferred to the appellate court. You know, the General Procedural Code is Code of Criminal Procedure 1973. That is presently applicable in India. Sections 372 to 394 in the CrPC deal with this subject, criminal appeals. If you go through the bare provisions starting from section 372 up to 394, you will find that the legislative language that has been used many a times does not provide clarity. You can say the ultimate law which you need for purposes of preparing the appeal, submitting your arguments to the appellate court, they are to be found only in the leading judgments of the Supreme Court. Before starting with this subject point-wise, I will draw your attention to one article in the Constitution of India, and that article is 141, Article 141 of the Constitution. It says, the law declared by Supreme Court of India shall be binding upon all courts within the territory of India. It means if a law has been laid down by the Supreme Court by way of interpretation, by way of its power of interpretation, then that interpreted law is the final law. That interpreted law is the binding law upon all, whether it is a court, trial court, appellate court, or any other court. Why it is so? Because it is the mandate of the Constitution. Article 141 of the Constitution mandates so. These interpreted laws are called rulings. Every day you see in practice that in support of their submissions to the court, lawyers give rulings in bunches to the court. If there is a conflict, there is a doubt whether the bare provision given in the bare act is binding, is final, or its interpretation given by the Supreme Court in its judgment. So your understanding should be that it is the interpretation of the provision given by the Supreme Court in its judgment that is final, that is binding, not the mere legislative provision given by the legislature, which is available in the bare act. So the true law, binding law, ultimate law, final law in our system comes only from the interpretations of the Supreme Court. It is only there where no interpreted law of the Supreme Court is available. Anyone is free to make his or her own interpretation of the provision. Interpretation is available, what is called ruling. Then only that ruling will cover the field. The law laid down in the judgment of the Supreme Court will cover the field, not mere provision contained in the bare act. So today, when we will be discussing this subject, I will take you through different difficult concepts of the subject with the help of Supreme Court rulings, leading Supreme Court rulings. So let us start with the subject. Section 372 CrPC. It says, an appeal would lie to an appellate court only when it is so provided in the law. Which law? For the time being, the CrPC. If there is any special law, it's not correct to say that appeals are preferred only under the Code of Criminal Procedure. Appeals are also preferred to appellate courts under various special legislations. If there is any special act which provides an appellate forum, which provides for the manner of preparation of memorandum of appeal, petition of appeal in a particular manner, then that special procedure, a special provision given in the special act will cover the field. If there is no such special procedure given in the special act, then the Code of Criminal Procedure will apply. Sections, initial sections of the CrPC, sections 4 and 5, they apply. They clarify this situation, this thing. So, an appeal is a statutory remedy. Appeal can be filed only when it is so permitted under some law. In CrPC, section 372 says, yes, if an appeal is permitted under the law, it will be filed in accordance with the sections of this chapter. Means 373, 374, 375 and onward. When is an appeal filed? From whose order or judgment appeal is filed? It is always filed from the orders of the lower forum. Which one is the lowest forum in our judicial system? The district judiciary, which is a 3-tier system. In criminal side, there are magistrates, junior division, magistrate senior division, what are called civil judges junior division, civil judges senior division in civil side. In criminal side, the hierarchy among magistrates is capable of having power to exercise 3 years sentence and up to 7 years, above 3 years and up to 7 years. The additional chief judicial magistrates, metropolitan magistrates, and judicial magistrates, they are almost equivalent. Additional chief judicial magistrates and chief judicial magistrates. In your Bombay city, metropolitan magistrate, additional metropolitan magistrate, and chief metropolitan magistrate. This is the structure of magistracy. In big cities, in CrPC, it is provided where population of the city exceeds 10 lakhs, there would be metropolitan magistrate, additional metropolitan or chief metropolitan magistrate. Below 10 lakhs, chief judicial magistrate, additional chief judicial magistrate, and judicial magistrate. But it depends upon the state government in consultation with the state high court to notify or not to notify in which city they want to have metropolitan or chief metropolitan or additional chief metropolitan magistrate. It's a policy matter. Leave this question aside. It's not so important for you. What is important is the subject today. An appeal can be filed only when it is permitted by law. You must have seen how a petition of appeal is drafted, how the grounds are taken. Generally, in practice, you file appeal against the judgment of conviction recorded by the magistrates. It is filed to the sessions court, and as the sessions court or additional sessions court has recorded the judgment of conviction, then the appeal is filed to the state high court. So this is the prescription of law given under section 374 of the CrPC. If a magistrate has recorded conviction, then appellate forum is sessions court. And if the sessions court has recorded the conviction, then the appellate forum is high court. And if the high court itself has tried the case and recorded judgment of conviction and has passed sentence, which can be the appellate forum? The Supreme Court. If you go through the bare provision, bare language of section 374 of the CrPC, you will find this prescription of law. My state is not the forum of appeal. Session judge is, high court is, Supreme Court is. From magisterial court, appeal goes to sessions court. From sessions court to high court. From high court to Supreme Court. You can say that there are 3 tiers of appellate forums in CrPC as provided in section 374. Of course, 378 is also there where appeals are filed against acquittal. I will be dealing with that issue later on. Right now, I am just talking of convictions. Appeal against convictions. Sessions, High Court, and Supreme Court. These are 3 forums where criminal appeals are filed. Since you people practice at the basic level and you deal with the convictions recorded by magistrates and session judges, either you file your appeal to the session judge or to the high court of the state if the conviction or acquittal was recorded by session judge. What are the functions of appellate courts? But I think I should first let you know what is your role as lawyer to prepare the petition of appeal. How should you prepare your appeal? It is you who drafts the appeal and then presents it to the court, to the appellate forum. So just imagine my state has recorded conviction, has passed his judgment and sentenced an accused with imprisonment up to 2 years. Suppose it is a theft case, 379. Appeal has to be filed. Where this appeal will go? To the sessions court. How should you draft your appeal? You know, if the guilt is proved by evidence, only then a trial court can record judgment of conviction. Only then accused can be sentenced. Otherwise, the trial will end into acquittal. So what is necessary for recording conviction by trial court? Proof of guilt. And in criminal trials, this proof is different from the proof required in civil cases. In civil cases, it is mere possibility of the case of the plaintiff, preponderance of probability. This phrase means if the plaintiff has been able in a civil case to make out a possible case, his suit may be decreed by a possible case. Rigor of proof is not that harsh in civil cases as it is there in criminal cases. In civil cases, only preponderance of probability will work. It means some little evidence may also convince the court. Little amount of evidence may also convince the civil court in passing its decree in favor of plaintiff. But little evidence in criminal side will not work. It should be beyond all reasonable doubts. An accused has to be convicted at trial in criminal side only when the guilt of the accused is proved beyond all reasonable doubts. There should be no second scope for second view. There must not be any chance, any scope for appreciation of the evidence in a different manner. So this standard of proof in civil and criminal cases differs in that sense that in criminal cases, the standard is beyond reasonable doubts. In civil cases, beyond reasonable doubt theory is not applicable. Only little evidence may also convince the court to decree the suit of the plaintiff. So when you draft your appeal, you should carefully read the charges framed against the accused. If it is a warrant trial having ended into conviction by the magistrate, and if it is a summons case, obviously there is no charge framed. You will have to go through the accusation contained in the FIR, the material allegations, disclosing the ingredients of the offenses in the case diary, in the police report that was submitted by the police under section 173(2) of the CrPC. Take an example, 379. Theft. What are the ingredients of a theft? There must be some owner of movable property. This movable property must have been taken out from the possession of the true owner without his consent. There should be removal. There should be dishonest intention. These are 4-5 ingredients of this offense as defined in section 378 of the IPC. Immovable property, removal without consent of the owner, dishonest intention. So while drafting your appeal, you carefully examine the evidence that has been led by the prosecution to prove its case. Suppose there are eyewitnesses who have deposed before the magistrate that they had seen the accused, the convict, committing the theft. There would be examination in chief, then there would be cross-examination. The oral testimony of a prosecution witness would be available in these two parts, examination in chief and then cross-examination by defense. You carefully read both the chief and cross and find out whether the witness has been able to prove the ingredients of the offense. 378, whether these 4 ingredients of the offense of theft are available in the testimony of the prosecution witness. If they are missing, you note down it, make it a ground of appeal, questioning the validity of the judgment of conviction recorded by the trial magistrate. If there are documents, you examine the document carefully. Let you see whether it was a public document or a private document, or it was electronic record. What sort of evidence has been led by the prosecution? You give your thought to it. Go to section 3 of the Evidence Act. It says there are 2 types of evidences. One is oral, other is electronic record, other is documentary evidence, including electronic records. With the passage of Information Technology Act 2000 by Parliament in the year 2000, Evidence Act was drastically amended. So was amended Section 3. In documentary evidence, electronic records were also included. If prosecution has produced, suppose only oral evidence and documentary evidence, generally 2 sorts of evidences are there in a case, oral and documentary. I just pointed out that you see whether the witness has proved a particular fact in his chief or cross, whether the ingredient of the offense has been proved, pointed out in the oral testimony. Next, you come to the documentary evidence. There are 2 sorts of documents, public or private. What are public documents? Section 35, Section 34 of the Evidence Act. If you read together, Section 35, Section 34, you will get clarity what are public documents. There are 3 postulates of a public document. If a document has been prepared, number 1, by a public servant, number 2, in discharge of his official duty, number 3, document must have been required by some law to be prepared as such. Again, enumerate. First condition is document must be required to be prepared by some law. Number 2, it should be prepared by some public servant. Number 3, public servant must have prepared this document in discharge of his official duty. If these 3 conditions are fulfilled in respect of a document, that document would be called public document. If any of these conditions are not fulfilled in respect of a document, that document can be called only as a private document. A bill deed, a letter written by you, an application written by you, all these are private documents. But land record maintained by Taluka, revenue officer, land officer, extracts, certificates of deaths and births and deaths, maintained by municipal corporation, municipalities. Voter list. These are the documents which are required under some laws to be prepared. Who prepares it? Public servant, government servant prepares. How does he prepare it? In discharge of his official duty. Here context is, you just notice what is the nature of the document that has been produced by the prosecution in support of its case. If it's certified copy of a public document, of course, it is admissible per se. Automatically, it is admissible without proof of its execution. You know, section 76, 78 of the Evidence Act, they say there is no necessity to produce the original public document. If the document in question is a public document, a certified production of a certified copy will suffice. But if it is a private document, the original must be proved, must be produced and then proved. If original has not been produced, then an explanation should be offered by the party producing the document as required by section 65 of the Evidence Act. If the original is in possession of the opposite party, then a notice should be given under section 66 of the evidence to the opposite party to produce the document before the court. And if opposite party fails in response to that notice to produce it in the court, only then secondary copy will be admissible. While preparing your appeal, you must see whether the document is public or private. If it is a public document, then it should be a certified copy. There is no necessity for production of original. If it is a private document, it must be in original. If original has not been produced, so what has been the explanation offered by the party relying upon this document? Why the party withheld the original and produced only secondary? I don't think you people start with this approach while examining the admissibility of the document produced against you, the evidentiary value of the document. In respect of a private document, two things need to be proved. One is execution of the document. Other is content of the document. If I start giving you talk on such subjects, what is execution, what is content, so I think it will be doing injustice to advocates who are in practice every day, you know. So I will not go into these details as I go when I face the junior magistrates who have just been inducted and they are subjected to foundation level training. You know, mere signature or thumb impression upon document, if it is proved, then it is called execution has been proved. Suppose a bill deed has been written, testator has put his thumb impression. There are two attesting witnesses. One has been called as attesting witness before the court and the witness is deposing, yes, testator Mr. X had put his signature before me on this bill deed. This is in front of me today in this court, and I identify and his thumb impression, he had gone through the contents, and in our presence he had put his thumb impression or signature. This much statement will amount to proving the execution of the document. Here execution is proved by the deposition of this attesting witness. Simply suppose you have written a letter and you have signed it, or the letter is in your handwriting. You come as witness to the court and say, yes, this is the letter which I had written on such and such date, it is in my handwriting. And if you have put your signature on it, if you say, I identify my signature, this was the signature which I had put on such and such date. When you make this statement, what do? To prove the execution. To proving the handwriting, proving the signature or thumb impression is called proving execution. Once execution is proved, document becomes admissible. But still there is no guarantee in law that its content will be taken on its face value merely because it has now become admissible on proof of its execution. No, contents will have yet to be proved. Witness will have to state that all the contents of this document are true. I stand witness to it. The person whose signature is available, who is the maker of this document, he had dictated. Suppose in a criminal case, an application was presented to the SHO for registration of FIR. So application will contain the signature of the complainant, informant. He will come before the court and will prove his signature upon this application. Will say that this is the application which I had given to the SHO on such and such date. It contains my signature. I prove it. Execution is proved. This application is now admissible in evidence. But still not the contents. He will have to state the entire story that is there in the application. When he will state about the contents before the court, will prove by his chief and cross, only then contents will be taken to be proved. To let you see while preparing your appeal whether the prosecution had called those witnesses and had got the execution of the private document proved, had got the contents of the document proved, had got the ingredients of the offense for which accused has been convicted proved. And if you find any lacuna, any shortcoming, then note it, make it a ground of attack, make it a ground in your appeal to question the validity of the judgment of conviction passed by the trial court. I leave this subject to your questions. I will proceed here from to other points. What is the duty of appellate court? An appeal has been preferred against judgment of conviction before the session judge. You have argued the appeal. What is the duty of session judge? Or suppose ki session judge had recorded conviction, appeal has been preferred to the high. It is first appeal. What is the duty of first appellate forum? Section 386 CrPC provides for the duty of the first appellate court. It says an appellate court has twofold powers. One, that of the trial court, other of the appellate court. All the powers which were earlier vested in the trial court, they are now available to the appellate court, plus additional powers of the appellate court that have been enumerated under section 386. In short, you can say an appellate jurisdiction is very vast jurisdiction. It has double jurisdiction. One of all the powers of trial court, other what has been additionally given to it as appellate court. So an appellate court can reappreciate entire evidence. It can record fresh findings. It can agree or disagree with the finding of fact recorded by the trial court. It can enhance the sentence. It can reduce the sentence, lessen the sentence. First appellate court's duty is not to hastily agree with the finding of fact of the trial court. It is duty bound to appreciate the entire evidence afresh as available on the record of the trial court. I'm again repeating it. The appellate court is duty bound to reappreciate. I'm using the word re to again appreciate the entire evidence on record. Appellate court is duty bound to come to its own conclusion. It cannot simply go through the judgment passed by the lower court and record a few lines that after going through the judgment passed by the lower court, I am convinced that the finding of fact is okay and there is no need for this appellate court to disturb the finding. Judgment is a qualitative judgment and I agree with the conclusion reached by trial court. And appeal lacks force and it is therefore dismissed. No, they can't say like this. These concluding lines they can add, but only after having done the lengthy exercise of appreciation of entire evidence available on the record of the lower court. An appellate court will act like a trial court. Please let it be clear to you. When you argue an appeal before the first appellate court, you should address the first appellate court, the judge, appellate judge, as if you are arguing before the trial magistrate, before the trial court. You take the appellate judge through all those pieces of evidence, material pieces of evidence on record, which are there to disprove the case of the prosecution. Your approach should be for what penal sections accused has been convicted. I had taken example of section 379. You must keep in your mind what are the ingredients of those offenses, of that offense. If any of the ingredient is missing, it has not been proved. The accused would be acquitted by the appellate court. So it's your duty to see whether the prosecution had been able before the trial court to prove all the ingredients of the offense out of evidence led by it, to convince the appellate court how the ingredients of the offense were not proved before the trial court. If you are able to convince the appellate court out of evidence on record that ingredients of offenses were not proved, still conviction was recorded by magistrate, appeal would be allowed, because duty of the appellate court is to discharge the role of the trial court. An appellate court cannot say, no, being appellate court, I will not do that exercise, which was done by the trial court. No, appellate court has no other choice except to examine the entire evidence afresh. It will not be swayed away. It will not get itself swayed away by the finding recorded by the trial. It will record its own findings, will do its own exercise, will reappreciate again, appreciate afresh the entire evidence, and then will come to its conclusion. It is another matter. In its final conclusion, appellate court is convinced that there was evidence. My state had rightly convicted. All right. Now, in last para, appellate court may agree with the trial court, but it's not mere agreement of the appellate court will work, because appellate court will have to work as a trial court. Don't be misled that you are arguing an appeal before the appellate court. No, not at all. Not at all. Before assaulting the finding of the trial magistrate, you assault the evidence on record. Draw the attention of the appellate judge. Please, honorable appellate judge, look here. There was no such evidence which could have proved the ingredients of the offense. Therefore, conviction is bad in law. Assailing the finding of the trial magistrate is altogether a different thing. If you simply question the finding without referring the evidence on record, it will not work. Your duty as arguing counsel would be to take the appellate judge through the evidence available on the record of the magistrate, trial court. I don't know how you people put forth your case. You should adopt such type of approach, because duty of the first appellate court is to analyze, appreciate, evaluate the entire evidence afresh. If you want to see this position of law in respect of criminal appeals, powers of first appellate court, I was discussing powers of appellate court, duty of appellate court, first appellate court. Means section 386 of the CrPC. The appellate court's duty is to appreciate the entire evidence afresh. Again, appellate court cannot simply agree or disagree with the finding of the lower court. It can agree or disagree with the finding of the lower court only when the appellate court has done its duty. What is that duty? To read the entire evidence completely, wholly, fully, and then make up its mind whether out of evidence offense was proved or not. This is the duty of the appellate court. And this is your duty to point out to the court, appellate court, the offense was not proved. Let you go through the entire evidence, then draw your points from the evidence. How offense was not proved, what were the ingredients of the offense. When it is called offense was not proved, what do you mean by this statement? Offense was not proved. This is a vague statement. It means the ingredient of the offense was not proved. If an offense contains 3 ingredients, so all the 3 must be proved by evidence. Where is that evidence on record? If you simply argue before the appellate court, honorable appellate court, offense was not proved, no, this is loose statement, vague statement. This statement, this submission made by you lacks force of law. You are not specific, not particular in pointing out how the offense is not proved. Offense is not proved, it means ingredients are not proved. What are ingredients? 1, 2, 3, 4. Which one is not proved? Whether all are not proved or any one of the 4 ingredients is not proved. The offense will fail, case will fail, even when a single ingredient is not proved. So this should be the approach of an efficient advocate, drafting the appeal, arguing the appeal. If you have been able to open this website, lawhelpline.in, so please come and I will take you point by point. In this compilation, I am taking you through this article, Appeal Criminal. I'm at para 1D. Appellate court must examine evidence of each prosecution witness under section 386 CrPC and record its finding. This was also the duty of the trial court. This is also the duty of appellate court now. If there are more than 1 prosecution witnesses examined before the trial court, duty of the trial court and now appellate court is to examine the evidence of each and every PW separately. It's not that there are 4 PWs and the trial magistrate or the trial magistrate or appellate judge is saying yes, after having gone through the oral evidence of PW1, PW2, PW3, PW4, I am convinced that the charge was proved. No, this finding is vague. This should be set aside by the superior forum. The duty of the trial magistrate was take up PW1 first, then PW2, then PW3, then PW4. And same was the duty of the appellate court. Please keep it in your mind that first appellate court will have to act as trial court. It is misnomer that it is appellate court. His duty is just like trial court. It is another matter. Appellate court does have the additional powers. It can partly reject the finding of the lower court. It can fully reject its finding, may substitute fresh finding, add finding, subtract finding, enhance sentence, may reduce sentence. All these are the powers of the appellate court. But while appreciating the evidence, there is no difference between the role of appellate court. Even at the Supreme Court stage, there would be no difference. The entire evidence will have to be gone through by the appellate court. In civil matters, second appeal under section 41, section 100 of the CPC is examined only on substantive question of law, but it is not the case in criminal appeals. It is the evidence that is always examined. So when you argue appeal, you must take the trial, you must take the appellate judge through the entire evidence and convince him how the ingredients of the offenses were not proved. Point number 1F of my compilation, appeal criminal. Point number 1F, no appeal, revision, or bail application, etc., can be heard and decided by an additional or assistant session judge unless transferred to him by the session judge. You know, appeal is preferred to appeal, revision, bails, everything is preferred first to the court of the sessions judge. Either he can himself hear and decide it, or he may transfer to any additional session judge. So unless it is transferred, it will be heard and decided only by the session judge. Appeal against conviction. Appeal against conviction. Section 374 deals with appeals against convictions. It says, I'm taking you to the point number, it is point number 3 of my compilation. Appeal to session judge against conviction by magistrate. If the magistrate has recorded conviction and the sentence passed by magistrate is not beyond 7 years, appeal will go to the session judge. And if the conviction has been recorded by the session judge or additional session judge, appeal will go to the state high court. So this is the provision in CrPC. If it is acquittal, 378, type 378. I just float a question, whether there would be any difference of approach, whether there would be different approach on the part of the appellate court while dealing with an appeal against acquittal and appeal against conviction. Answer is yes. When judgment of acquittal has been passed by the trial court, then appellate court under section 378 would interfere only when there are compelling reasons. What does mean compelling reasons? When appellate court will feel compelled to interfere, convert the acquittal into conviction. Saying theoretically, when appellate court will feel compelled, it will convert the acquittal into conviction is easy, but in practice to apply this into a given case is quite difficult. Compelled means unless there are reasonable causes, convincing reasons to disagree with the magistrate, with the lower court, his finding has not to be disturbed by the appellate court. In a judgment of acquittal, the innocence of the accused has been recorded. This innocence can be converted by appellate court into guilt only when the appellate court is so overwhelmingly convinced that the magistrate committed blunders in not believing the evidence, not relying upon the evidence led by the prosecution. Suppose there is an incident of physical assault, section 323, 540, 506 of the IPC. Magistrate has recorded acquittal. The injured witness, 323 or 324, whatever may be the penal section. The person who was injured, he was examined before the trial court as PW, but the magistrate has disbelieved him that he had not seen the incident. How can magistrate record a finding like that? If the magistrate says the accused could not identify the assailants unless there are very cogent reasons, how can magistrate record a finding like that? If a person who is under assault, if he will not identify his assailants, then who else could have identified? The human tendency is a person who has been harmed by someone, who has been assaulted, who was assaulted by accused, he will not spare him. It is another matter he may add some innocent persons, false implication due to enmity, etc. But at least assailant would not be spared by him. This is human tendency. If he says that Mr. X had assaulted me with hockey on such and such date at such and such place, normally this statement, this oral evidence of the witness has to be accepted. An injured witness cannot be ordinarily disbelieved. So is the case with a witness who claims to have seen the incident, unless there are cogent reasons he was not present on the spot. It can't be said that witness had not seen the incident. If you have mastered the art of appreciation of evidence, only then you can draft a good appeal. Only then you can argue appeal in an excellent manner. So what is the law? Where from you should learn it? You go through my article available on this site, lawhelpline.in, appreciation of evidence in criminal trials and criminal appeals. Appreciation of evidence in criminal trials and criminal appeals. With the help of leading Supreme Court decisions, I have given enough prescription, enough material. If you go twice, thrice through this article, you will have sufficient clarity and will be able to draft and argue the appeal properly. In fact, arguing an appeal requires clarity regarding law of appreciation of evidence. The basic function of appellate judge is to appreciate the evidence. The basic function of the advocate arguing appeal is to be well familiar with the law regarding appreciation of evidence. Virtually, role of the judge and the advocate is the same. There is no different law for judge and there is no different law for you. Law is the same. Both are required to be familiar with the law. You can't depend simply upon the judge that he will do everything. It's another matter that if you perform poorly in arguing the appeal, in drafting the appeal, still judge is under obligation of his duty. He will have to apply the law correctly. He will have to appreciate the evidence properly. Will have to record the finding properly. Will have to discharge his role as appellate court as well as that of a trial court. He will do his duty. But since you had drafted, you had presented, you had argued the appeal, it's your duty too to take the judge, to take the appellate judge through all the material pieces of evidence which are as per you relevant for disproving the case. So in an appeal against acquittal, appellate court will hardly interfere unless it is fully convinced that the finding recorded by the trial court was perverse. If absolutely unreasonable view was taken in appreciating the evidence by the magistrate, only then in an appeal against acquittal, appellate judge will interfere. Otherwise, he will give his approval to the acquittal judgment of the magistrate. At appellate stage, one thing is noticed: many a times parties seek to produce additional evidence. 391. Type 391. Section 391 of the CrPC. It says, in appropriate cases, production of additional evidence can be permitted by the appellate court at the appellate stage. Ordinarily, an appeal has to be decided. If you have opened my article, then see point number 8A, additional evidence at appellate stage. Additional evidence can normally not be permitted to be produced by the prosecution as well as by the defense, unless they convince the appellate court what were those justifiable reasons which prevented them to produce this evidence before the trial court. Suppose that by the time the judgment was passed by the lower court, the document was not in the knowledge of the party. Obviously, could not have been produced, or the copy of the document was applied, or it was traceless and it could be traced only after the judgment was pronounced by the trial court. So hence such justifiable reasons have been offered to the court, then power of appellate court under section 391 can be invoked. And second condition is that the additional evidence, whether documentary or oral, it must be capable of reflecting upon the outcome of the conclusion reached by the trial court. Means if there was conclusion of conviction or acquittal before the lower court, then if this document is taken on record at the appellate stage, it might change the outcome. It should be relevant. It should reflect upon merits. It should not be allowed just to fill up the lacuna. Supreme Court has again and again insisted to fill up lacuna, additional evidence can't be allowed at appellate stage, because when an additional evidence is taken on record, it will require a fresh finding. How was the magistrate or lower court responsible when this document was not there? It means that now a new finding will be recorded at appellate stage, and it might go either in favor of this party or that party. So normal practice is that production of additional evidence is not allowed at appellate stage, but under justifiable circumstances, under convincing circumstances, additional evidence can be permitted at appellate stage. Then acquittal in complaint case, type 3784. If acquittal has been recorded into complaint case, what would be the law? In a case where acquittal by magistrate has been recorded in a non-bailable and cognizable offense, it is the district magistrate who may direct the public prosecutor of the district to present appeal before the session judge. And if it is a sessions court who had recorded the judgment of acquittal, then it is a state government that may direct the public prosecutor, government pleader to present the appeal to the high court. But when it is complaint case, then appeal to session judge will not lie. Appeal will go to the high court. Relevant section is 378.4, 4014 CrPC, 401 subsection 4. 378.4, 378.4, 4014. You read these two sections conjointly and then read the Supreme Court judgment on it. In a complaint case, appeal lies to the High Court under its permission. And if the High Court permits, yes, against acquittal, appeal is being entertained, it will be decided on merits. It can decide. May I agree or disagree with the funding of the trial court? Then I should take you to the time barred appeals. Point number 6A, Section 115, 115 of the Limitation Act 1973. It provides for the limitation period to prefer the appeals, 30 days, 60 days, 90 days. If there is a sentence of death by session judge, additional session judge, then 30 days, within 30 days, record would be submitted to the state high court under section 366 of the CrPC. Convict does have the option to prefer his appeal, but if an appeal against conviction recorded by magistrate has to be filed to the sessions judge, then this limitation period is 30 days. Within 30 days, he will have to file the. What will happen if the appeal has not been filed within this 30, 60 or 90 days limitation period? Then section 5 of the Limitation Act applies. You consult the rulings which I have given on the relevant point. 6B, condonation of delay in time barred appeals. Host of rulings I have given here. All these are from the Supreme Court of India. Supreme Court says the law of limitation is procedural law. If the party has been able to convince the court that there were justifiable reasons preventing him from filing the appeal within a statutory period of limitation, then normally limitations should be ignored. Delay should be condoned. Section 5 applications should be allowed, and applications appeals should be entertained to be decided on merits. So this is the hyper-technical view. Harsh view should not be preferred by appellate courts in entertaining the appeal, because decision on merits is the practice. Doing justice is the objective of law, of courts also. Laws are there to do justice. Courts are there to do justice. On technical reasons like limitation, etc., the doors of the court should not be shut. Parties should not be forbidden to invoke the power of the court. Doing justice is the bounden duty of the court. The liberal approach is applied by the appeal courts in condoning the delay in preferring the appeal. So when you move any application under Section 5 of the Limitation Act for entertainment of your appeal to be decided on merits, you must see these rulings. You cite many rulings I have given. It is futile to cite one of them. If you have opened this site, you must be watching it. Dismissal of appeal in default. Point number 7A. It's not permissible. Once an appeal has been admitted, it has been taken on board by the session judge or by the High Court for decision on merits, and for certain reasons, the appellant or his counsel could not appear on the date fixed. So appellate court cannot dismiss the appeal in default. They are bound. Appeal cannot be dismissed in default. It has to be decided only on merits. Not pressed. Once having filed the appeal, the appellant can't say, no, I no more press this appeal. No. After admitting the appeal, the only option available with the appellate court is to decide the appeal on merits. It can't be allowed to be withdrawn. It can't be dismissed in default. It can't be dismissed as not pressed. These are the rulings from the Supreme Court of India. Point number 7, APC. Then non-appealing convicts benefit of appellate order to extend to them. Suppose at a trial before the magistrate, 4 accused persons were convicted. Only 2 of them went into appeal against conviction under Section 374. 2 did not go into appeal. Appeal was filed just by 2 or just by 1. After appreciating the evidence, the appellate court finds the judgment of conviction is bad in law. There was no evidence, ingredients were not proved, offenses were not proved, conviction is bad. It will set aside the judgment of the lower court and the accused would be acquitted. Here only one accused had gone to the appellate court. Remaining 3 had not filed the appeal, but the benefit of this judgment that has been passed by appellate judge in his judgment will be extended to all the remaining 3 convicts who had not preferred their appeal. So the benefit of appellate judgment goes even to those convicts who had not filed the appeal, provided their cases were on identical footings. A, B, C, D, 4 accused were convicted for different penal sections. One was convicted for 323, other 324, other 504, other 506. This 323 went into appeal. He was convicted only for this offense in one single penal section, 323. Now here, the appellate benefit of appellate judgment will not be extended to B, C, and D because they had been convicted under different sections. But if all were convicted for the same offense and the appellate court found that the prosecution had failed to prove its entire case, then even if appeal was filed by one, all remaining three will be acquitted. Benefit will go to all the three, though they had not filed the appeal. 2019 Supreme Court, 5 Supreme Court, host of Supreme Court cases are here. Hearing of counsel for appellant and hearing of public prosecutor. You know, hearing is the most cardinal part of our judicial system. It's a part of natural justice also. Audi alteram partem. You know, there are three principles, what are called natural justice principles: rule against bias, no one can be judged in his own cause, and providing hearing before condemning or passing adverse order to the party. So these are three natural justice principles. In Latin term, they are, this hearing rule is called audi alteram partem. Here the other party also provide opportunity of hearing to the party. In simple words, this means this. But if absence of the counsel or the appellant is deliberate, they have knowledge, date is fixed today, still they are not appearing, court may or may not adjourn the case. Court can proceed further, may decide the appeal on merits. But if the party or his counsel doesn't have the knowledge of the date, then appellate court cannot decide the appeal without providing them hearing. Here, duty of the appellate court is to issue notice to the counsel for appellant and to the public prosecutor as well, who is appearing for the state. And then after hearing both of them, appellate court will pass its appellate judgment. Hearing is normally the rule. Court should respect it, provide it. But if deliberately appellant is not appearing, it's not today is fixed for appeal and none has appeared, it should be dismissed. Normal practice is that judge should adjourn. Though he is not bound, he may adjourn, may give one more opportunity, may wait for certain unavoidable reasons. It might be the party could not attend or his counsel was not instructed properly and could not appear. But if on next date also the appellant or his counsel doesn't appear, then court is not obliged to wait them for indefinite period of time. Court may proceed and decide the appeal on merits. Once having admitted the appeal, it will be decided on merits. Point 11a, remand for retrial. If material evidence on record was not appreciated by the lower court, finding was not recorded it. Had the trial court appreciated that material evidence, the result of the case would have been different. If the appellate court feels so, then it has two options. Either it can itself appreciate the evidence, like trial court, record finding of fact which it thinks it would be proper, or alternatively, appellate court does have power to remand the case back to the trial court by setting aside its judgment with the direction to appreciate the entire evidence afresh and pass fresh judgment. What is called remand. Court does have the power of remand. But normally, because this power of appreciation of evidence is available to the appellate court, the Supreme Court says that normally if the case can be given finality, even the appellate stage, then remand should not be ordered. Remand should be ordered for some good reasons. Ex parte disposal of appeal, point 11b. Supreme Court says no, it's not a civil case. What is ex parte? Here both the sides. If the accused is unable to engage a liar for ignorance, for poverty, so it is the duty of the state at the expense of the state from District Legal Service Authority, from High Court Legal Services Committee. Advocates are on roll. His services should be provided to the party who is unable to engage the counsel. You know Article 39A in the Constitution. It was added in 1976. The purpose of Article 39A was to provide legal aid, services of advocates. Legal aid is provided in different forms. One of them is services of lawyers. So it is the duty of the District Legal Service Authority, State Legal, NALSA, SALSA to provide advocate. Appellate court should write to the SALSA, NALSA, District Legal Services Authority, to provide services of some advocate to the appellant who is unable to engage the liar. This is mandate of Article 39A. Then appeal, bail at trial court or appellate stage. Section 389. I am referring to paragraph 13(1) of 13A1 of my compilation on criminal appeal. Relevant consideration for bail in appeal. You know कि a judgment of conviction is passed by trial court, but the sentence pronounced does not exceed 3 years, or the offense was bailable and the accused was on bail, then trial court's duty is to release the convict on appeal under section 389 for 30 days to prefer appeal to the sessions judge. By the time an appeal can be preferred, the statutory period, for that interim period, trial court can grant bail him. You go and file your appeal if you want. The practice is that after conviction, accused person moves application to the trial magistrate himself. He grants bail, interim bail for 30 days for the period of appeal. So these are the provisions here, but you must keep one thing in mind. Only sentence can be suspended, stayed. Realization and fine can be suspended, can be stayed, but not the effect of conviction. Representation of People's Act 1951. It says, section 128A of the Act, if an MP, MLA, minister is convicted and has been sentenced with imprisonment exceeding 2 years, so he will lose his membership of the legislative house. But if the effect of conviction is stayed by the appellate court, then he will not be disqualified. He will stand disqualified only when conviction remains attached to him. Stigma of conviction remains attached to him. And if operation of this stigma is stayed, then he will not be treated to be disqualified from the house. But the Supreme Court has come down very heavily on this practice. It is not allowable. Supreme Court says in many cases, I have given this point 30, 13, ABCD, many Supreme Court cases. A trial court, an appellate court can suspend this sentence, the realization of file, recovery of fine, but it cannot suspend the operation of conviction, the operation of stigma, because stigma can be washed out only when the appeal is finally decided. Granting interim bail, releasing the accused on bail after entertaining the appeal, it doesn't mean that the appellate court declared the accused to be innocent. Innocence will be restored only when the appeal is allowed. Judgment of conviction is set aside. At interim stage, at interlocutory stage of bail, effect of conviction cannot be washed away, cannot be suspended, cannot be stayed. Compounding of offense at appellate stage, you know, section 320 of the CrPC says, section 320, subsection 5. It says, if the offenses are compoundable without permission of court, they can be compounded. Compounding can take place both at trial stage as well as at 325. Oh, 320, subsection 5. Then there is 357 CrPC. It says about compensation. The conviction has been recorded. Accused has been held guilty. Supreme Court rulings are there. 357 of the CrPC is also there, which says that some compensation apart from fine should be awarded to the victim of the offense. Then appeal from jail. Suppose that an accused is lodged in jail, his bail has been rejected. Now he has been convicted. He is unable to prefer his bail to the High Court or to the Sessions Court, as the case may be. The duty has been cast upon the superintendent jail to arrange necessary legal aid for him under section 383 of the CrPC. And there has been a very leading case of the Supreme Court, M.H. Hoskat, State of Maharashtra, year 1978 Supreme Court, ensuring that an appeal is filed by the prisoner to the appellate forum is the duty of the state. The local representative of the state government, the superintendent, he will provide necessary facilities for preferring appeal. And the duty has also been cast upon the District Legal Services Authority, DLSA, to see that if the convict wants to file the appeal, he should be given necessary legal aid, services of advocates, stationery, paper, typing, this and that, whatever is required, it should be provided to him free of cost at the expenses of the state, so that he may be able to prefer his will to the High Court.
Suppose an accused has served a term more than the punishment and is proved and is acquitted in appeal. What is the remedy?
There is a section in CrPC 436A. It says that if half of the maximum sentence provided for an offense has already been gone by the accused and he is still lodged in jail. So the duty of the court would be to grant him bail. It is in respect of an accused whose case has yet not been decided. Suppose for theft there is 3 years imprisonment. He is lodged in jail for 1.5 years, more than 1.5 years. Here, duty of the magistrate would be to grant him bail as a matter of right. Your question is slightly different. Question is, what are the remedies of an accused who was convicted by the trial court and in appeal, his appeal was allowed and his conviction was set aside, was acquitted? This is your question?
Yes, sir.
For such matters, there is no provision. He can file a suit for recovery of damages. What is called suit for recovery of damages for malicious prosecution. The complainant, the informant who had lodged FIR against him, who had got him prosecuted, convicted, and sentenced, and ultimately at appellate stage acquitted. His remedy is to seek damages. It is tortious liability, law of tort. He can file a suit for recovery of damages. This is his remedy, but that is civil remedy.
Okay.
Okay. My question is, sir was mentioning as per NALSA and SALSA, we should be getting some benefit even if the convict is in the jail to get the legal aid. But is it practically possible or it's only present in the CrPC?
Section 383 CrPC is there. If the accused is lodged in jail and he is convicted by the trial court and he wants to prefer his appeal, it is the duty of the superintendent of jail to arrange on his own all that what is needed for filing his appeal to the relevant appellate forum. Or he can write a letter to the district legal services authority to provide him necessary legal aid. Both are responsible. The duty of the Legal Services 30 Act 1987. Different forums are created under this act. DLSA, SALSA, NALSA, this legal aid committee at high court level, taluka level. Why they are there? They are statutory bodies. Their role is, their duty is to ensure that a citizen is not deprived of justice just because he is ignorant, he is poor, or he is otherwise unable to engage a lawyer for reasons of poverty, etc. That was the reason in furtherance of Article 39A of the Constitution, this Act in 1987 was passed by Parliament. This Legal Services 30 Act 1987. This is the progeny of Article 39A was added in the Constitution in 76 by Parliament. Why was it added? To ensure that legal aid is provided to everybody. Nobody is deprived of justice because of basically poverty, number 2, ignorance, etc. He has a right, constitutional right. I have mentioned the rulings of the Supreme Court in this. Have you opened this article of mine on Google? I have got in.
No, sir, I'm doing it from my mobile as I was driving.
So now you note down. Here are rulings.
Sure.
Supreme Court
the
guidelines.
Reason I asked this question is, when we did the jail visit, we found that every jail is overburdened and the limited number of police force available there. They don't have time to do their routine duty. So assisting a particular inmate is out of task for them.
It is a nationwide problem. Jails are overcrowded. Months, years are taken in trial. Problem is there. There can be no denial. There is huge gap between idealism and practice. Let us hope we will be having better system and better amenities. Our system would be faster than what we are having today. So these are the melodies, shortcomings in our system, and entire country is worried on it. Every day you must be hearing law minister, judges, this or that authority lamenting we are lacking in facilities, infrastructure, this, that. Problem is there, no doubt. At the same time, it is also not correct to say that the system is dysfunctional. System is functioning, but at slow pace. It takes time. And if any inmate is lodged in jail who is unable to contest his case, to defend himself, to protect himself from invasion of his rights, merely because he is not getting the services of advocate. So if you visited the jail, you should have written it to the DLSA, to the district judge of your district, inviting his attention that such and such accused is lodged in such and such jail. And when I interacted with him, he was saying he wants to prefer appeal, but he is ignorant and he is a poor person, cannot engage a counsel on his own. Therefore, please kindly provide him the services of some advocate. to prepare his appeal and file it before the appropriate appellate forum. You should write a letter like that. If somebody doesn't come forward for him, the ignorant person will suffer. Obviously, there are people in jail, not in all jails, but in some of the jails who do not care. They commit dereliction of duty. It's their duty under section 383 to bring it to the notice of the district legal service authority. The superintendent jail is there, but he is not performing his duty. So once it came to your knowledge, so as a responsible citizen, responsible officer, it's your duty to inform the relevant authority, the district judge, the secretary of the district legal service authority. So remedy is there. Somebody will have to tackle the problem. All right.
Importance of electronic evidence in this in the criminal court, and how it can be verified and charged, and how it can be produced.
You know, Evidence Act was drafted in 1872. Information Technology Act was passed by Parliament in the year 2000. All right. After how many years? 1872, then 1972, it took 100 years, then 28 years and 20. After 130 years, this Evidence Act served 130 years up to 2000. Then came Information Technology Act. Many electronic evidences were mentioned in that. With the evolution, development of technology, information technology, all the systems, you know, these electronic devices, which include telephone, computer, mobile, mail, social media, messaging, lot of things are going on in this field of information technology. So this branch of knowledge, this scientific branch of knowledge created new sorts of evidences. It started interfering with the existing system of law, the Evidence Act. If you go to the definition of word evidence, where is it defined? Where is the word evidence defined? Section 3 of the Evidence Act. When was it enacted? In 1872, 157 years back. Word evidence means, as per section 3, statement of a witness, oral evidence, what is called, or documentary evidence, which includes electronic devices. Many sections of the Evidence Act got amended in the year 2000 when IT Act was passed. Section 67A, 45A, section 67A, then 68A, 77A, 78A, 88A, capital A was added against many sections. If you want to enumerate all the sections of the Evidence Act which got amended, you go to my article, Appreciation of Evidence in Criminal Trials. You will find the list of sections of Evidence Act which got amended after passing of this IT Act in 2000. Your mobile, everybody uses mobile. What sort of evidence is created in mobile? Either you talk to someone, your voice passes from you through your mobile to some other person, or you send some message, you do messaging, you receive messages. This WhatsApp, lot many functions are being done only through this mobile. All these are electronic evidences. They are admissible in evidence. I'm giving you just one example. Today we are interacting here. I am giving this talk to you people. Suppose it has been recorded by tape recorder in your system. My voice has been recorded. So what I spoke, what I suggested you people on this subject under discussion today, everything is recorded. It can be just clicked and my voice can be heard anytime. It is electronic evidence. So is the case when one person talks to some other person through electronic device like mobile, like telephone. His voice can be recorded. These bribe takers, graft takers, smugglers, criminals, mafias, how are they tracked? The agencies, the police tracks them. GPS system, this satellite system, their location is traceable. Voice can be recorded. It can be overheard. It has exposed many mafias, criminals, and bribe takers, bribe seekers. In coming years, you will see that this electronic device will be playing very pivotal role in nailing the accused, nailing the mafias, the corrupt. And these are admissible evidences. Suppose there are two mobiles with A and B. A is talking to B on mobile. They talk for 5 minutes. Section 88A of the Evidence Act says that there would be a presumption that there was mobile A had talked with mobile B. there was a conversation between A and B through mobile. Presumption of lie is there as per section 88A. These two mobiles had talked. There was conversation between these two. Only presumption that is not attached is whether it was Mr. A actually who had talked. Same is the position when you send a message. Section 88A again says, suppose कि from one mobile a message has been sent to another mobile. So section 88 says कि there is a presumption of law that message had originated from mobile A and it had reached to mobile B from mobile A. But who had created this message? Who had actually sent this message from mobile A? There is no presumption attached to it. Presumption is only one. From mobile A, message was sent to mobile B. Who sent, who typed, who created this message, who forwarded it, it's a matter to be proved as any other fact. Just like any other fact is proved, the same will also be proved in that manner. Presumption will not be there. Mr. A, it was Mr. A himself who had sent the message. My mobile can be used by anyone. I have kept it somewhere. Somebody take it and pass a message from mobile to someone. What will be proved from this? My mobile was used in passing the message, but it can't be presumed that it was me who had actually passed the message. So, in similar manner, there are many evidences. Your voice, your digitized in this digitized way, your digital signature, your contents in mail, soft device, anything which is available in soft form in the hard disk, in computer, all these are electronic evidences. They are admissible. If any specific query you have regarding any particular issue, so you put and I will deal with that. Electronic evidence is admissible. Electronic evidence means any device which is used to create content in soft form. That is electronic.
So my question is related to bail, having surety, bond and everything. And as we know that a beggar can be a surety, but sir, what I see in the court that judges don't allow someone who is not in government job, who can't give like 20,000 bond or something like that. Is there any remedy if some kind of problem is faced by some person accused who is like poor and also ignorant of law?
Only recently, Supreme Court has issued notice to the center and states. There are many accused persons in jail who are still carcinating in jail, lodged in jail, because even after grant of bail, they are not able to furnish the sureties and bonds to the satisfaction of the court. So what can be done in such matter? In the year 2006, CrPC was amended. Section 436 of the CrPC, you know, it says that in bailable offences, accused would be granted bail as a matter of right, with or without bonds. Suppose in a bailable offence, accused has been granted bail by the magistrate, and after 1 week, within 1 week, he has not been able to furnish the bail bond and suit. Court will presume that he is a pauper, P-A-U-P-E-R. Pauper means indigent person, poor person, who has no means, who has no friends, no well-wishers, who can stand surety for him, and who can provide the papers, the bail bond, as surety to the court for his release from jail. So if in a bailable offence, an accused fails to furnish the bail bond and surety for 7 days, for 1 week, so he will be released merely on his personal bond. This is the law as of today. 436 2RA. What is the section exact I am quoting you? This is proviso to section 436. But if it is a non-bailable offence, then unless the accused furnishes the sureties, the bail bonds as directed by the court in the bail order, he will not be allowed to be released from jail. He will remain in jail. This is the position of law today.
So my question is related to the examination in chief, cross-examination and re-examination. Like as a fresh advocate or suppose if we go into the court, so at what during the trial time, at what instance does the examination in chief or cross comes into picture, and what is the procedure for it? Could you please enlighten us on this issue?
Very simple procedure. In a criminal trial, case has started on the basis of a police report that is charge sheet under section 173(2) of the CrPC. Then public prosecutor will examine the witness and his deposition will be recorded by the court, what is called examination in chief. What should be his deposition? What should this witness state in the examination in chief? What is the case of the prosecution? If it is a case of marpit, physical assault, so then the date, time, place where this incident occurred, who was the injured, who were the assailants, what was the weapon that was being used by the assailants in assaulting, in causing the injury to the injured. These are the particulars of the incident. He should state about it into his examination in chief. Depending upon the nature of the case, nature of the complaint, nature of the FIR, nature of the charges framed against the accused, deposition will vary from case to case. Examination in chief will vary from case to case. An examination in chief of a witness in a theft case, in a dacoity case, in a forgery case, and in a physical assault case can be identical.
Sir, no, the questions posed to the witnesses will be different, certainly. But sir, my question was like, what is the major difference between the chief and the cross? Like when I go on seeing the books, like there are books in the market, like 8,000 questions on cross examinations and chief examination in chief. So the questions appear to be a bit similar. So what?
Hardly, yes, this 1,000 case will hardly lead and take you anywhere because facts of each and every case differ. How can you apply particular question answer given in a book? It all depends upon the situation, what the witness has stated in chief. Cross-examination is done on the basis of examination in chief. All those facts which have been stated by the witness in chief, cross-examination is done on that. But it is not confined to only those facts. A cross-examination need not necessarily remain confined only to those facts which appeared in examination in chief. A cross-examiner can travel beyond that to add clarity to the facts stated by the witness. Normal rule is a question in cross-examination can be put to the witness on only those facts which have been stated by the witness in chief. But in order to get clarity, to deduce clarity from the witness, cross-examiner can put additional questions which have those facts also which have not appeared in chief. And it is an art. It is learned from practice. When some efficient, well-prepared defense lawyer is cross-examining some witness, you just remain present there, just watch how he is picking up his questions. One thing can help you in advance. You imagine the possible response of the witness during cross-examination. In advance, you prepare your own questions to be put to the witness during cross-examination. But before that, what will have to be done by you? To be thorough on facts. You thoroughly examine the prosecution case diary, the FIR. If medical legal report is there, then read carefully that medical legal report. Then what are the charges framed? What are the former statements of the witness who is to be cross-examined? You know, former statement of a witness given during investigation to the investigating officer under section 161 or to the magistrate under 164, they are used for contradicting or corroborating the witness. You must be well read, carefully read, again and again read the statement of the witness under 161, under 164, the contents in the FIR, the statement of the witnesses in case diary, which police has submitted along with the charge sheet. If everything is clear to you, only then you will be able to formulate proper questions to be asked to the witness when he is under cross-examination. It's a very responsible duty of an advocate who cross-examines the witnesses, and it all depends what is the degree of devotion and commitment of the lawyer, whether he simply appears and starts cross-examining without thoroughly going through the case diary and without preparing the questions in advance. If you want to properly cross-examine the witness, case to case, you will have to be thorough regarding the facts, regarding the allegations, regarding the material contained in the prosecution story in the case diary of the police. These are some tips which I can provide to you for cross-examining the witness.
So I was asking about the bail and surety, and what you said that if it is a bailable offense, within after a week, the magistrate will allow declare him a pauper and allow him a bail without surety and on a personal bond. But sir, what I saw in here in Mumbai, in front of my eyes, I saw that there was a 353 case, sir, in IPC 353, and it is a bailable offense. सर मतलब उस केस में क्या हुआ था, मैं उस केस को ऑब्जर्व कर रही थी जब मैं स्टूडेंट थी लास्ट ईयर की, तो 353 की केस थी, सेशन कोर्ट एमएम कोर्ट से मतलब सेशन कोर्ट से बेल मिल गया और फिर एमएम कोर्ट में उसमें जो भी श्योरिटी थी वो सब दिखाना था। 1 महीना हो गया लेकिन प्रॉपर श्योरिटी नहीं मिल रही है करके 2 लोगों को वापस भेजा एमएम कोर्ट के जज ने। फिर मैं खुद भी एज अ श्योरिटी गई थी, बट फिर भी 20,000 का मेरा बैंक भी लेके गई थी, फिर भी उन्होंने मुझे भी श्योरिटी करके नहीं लिया। उसमें जो 1 महीने का पीरियड था, ड्यूरेशन था, वो लैप्स हो गया, इसलिए और एक महीने का एक्सटेंड करके लिया था श्योरिटी मिलने के लिए। तो ये मैं पूछना चाहती हूँ, ऐसे केसेस में क्या रेमेडी होगा सर? और दूसरा मेरा क्वेश्चन, जैसे आपने कहा कि नॉन बेलेबल ऑफेंस में फिलहाल तो श्योरिटी देना ही पड़ेगा और मतलब पैसे भी भरने ही पड़ेंगे, बॉन्ड भी देना ही पड़ेगा, बट सर नॉन बेलेबल ऑफेंस में भी कुछ एक्यूज ऐसे हैं जो जैसे कि पुअर है और इग्नोरेंट है, वो पैसे नहीं भर सकते हैं और उनको लॉ का इतना नॉलेज भी नहीं, तो उनके लिए अगर रेमेडी नहीं है तो रेमेडी को उत्पन्न करने के लिए हमें क्या करना चाहिए, तैयार करने के लिए हमें एज अ नया एडवोकेट हमें क्या?
पहले तो बेटा एक बात ये बताएं, 353 आईपीसी 353 आईपीसी
यस सर।
असॉल्ट ऑन पब्लिक सर्वेंट जो है, ये अब कॉग्निजेबल और नॉन बेलेबल हो गया है। कॉग्निजेबल तो पहले भी था, अब नॉन बेलेबल हो गया है। किस तारीख से? 3 फरवरी 2013, फरवरी 13 से नॉन बेलेबल हो चुका है। ये नॉन बेलेबल है, इसमें 436 का प्रोवाइजो जो है कि 1 हफ्ते में बेल नहीं दे पाया, सिक्योरिटी नहीं दे पाया तो उसको पीबी
सर 1 महीना हो गया था, बेल का 1 महीने का प्रोविजन खत्म हो गया, इसलिए 1 महीना और एक्सटेंड
1 साल पे भी नहीं छूटेगा वो, क्योंकि अब सजा इसमें कितनी दिखा रहा है, इसमें हो
3
गई
years.
है 2 years और
2
5
years,
बोथ। तो 1 साल हो जाने पर वो इन्वोक करो 436A, क्योंकि मैक्सिमम सजा इसमें 2 साल है और 1 साल से ज्यादा वो हाफ उसका काट चुका, अभी ट्रायल नहीं कंक्लूड हुआ। ही इज नाउ इंटाइटल्ड टू बी रिलीज्ड ऑन बेल अंडर सेक्शन 436A।
सर बेल तो उसको मिल गया था, मैं वो कह रही हूँ, लेकिन श्योरिटी और फाइनेंशियल बॉन्ड वो भरने
देना पड़ेगा। अभी तक ऐसा तो कोई लॉ ही नहीं बना। अभी सुप्रीम कोर्ट ने 1 हफ्ता पहले ही नोटिस जारी किया है, भी है वही उन्होंने ऑब्जर्व किया था। लाइव लॉ पे पढ़ो तो हमने लाइव लॉ पे पढ़ा था 4-5 दिन पहले कि दे आर सेइंग कि he has written to me, it has been brought to our knowledge that many accused are languishing in jail, grant of bail, even after grant of bail, merely because they have not been able to furnish the sureties and bail bonds to the satisfaction of the court. How it is happening, what role NALSA, SALSA and DLSA are playing, we want to have clarity on, and what can be done to protect the fundamental rights as to personal liberty guaranteed by 21 of Constitution to people. So when some guideline will come from Supreme Court, then there will be different. As of date, the prescription is only provided to section 436 in respect of bailable offences, and of non-bailable it is section 436A का है। ये नहीं हुआ है स्वाति कि अभी बेल बांड ना दे, सिक्योरिटी ना दे तब भी छोड़ दो, अभी ऐसा नहीं है।
हाँ नहीं सर, मैं पूछ रही थी जैसे हम नए लॉ ग्रेजुएट्स है तो हम कोई पत्र व्यवहार करके या कुछ करके ऐसी कोई रेमेडी को लाने के लिए मतलब कुछ कर सकते हैं क्या अपनी तरफ से?
कर सकते हो। इफ यू वांट टू राइट, यू कैन राइट टू द लॉ मिनिस्टर ऑफ योर स्टेट इन बॉम्बे, कैन राइट टू द यूनियन लॉ मिनिस्टर। इन्हीं लोगों की पहल होगी। होम मिनिस्ट्री को भी लिख सकते हो, क्योंकि क्रिमिनल लॉ इज ए सब्जेक्ट ऑफ स्टेट एंड यूनियन बोथ। तो इफ द स्टेट गवर्नमेंट वांट्स टू अमेंड द लॉ ऑन दिस पॉइंट, यू कैन राइट टू योर स्टेट गवर्नमेंट इन महाराष्ट्र, असेंबली में बिल ला के अमेंड कर दें कि जो 1 साल तक, 6 महीना तक, 2 महीना तक जैसा करना चाहें। नहीं सिक्योरिटी दे पाता है तो उसको भी वो बेनिफिट मिलेगा जो बेलेबल वाले को मिल रहा है 436 वाइजो में।
Okay, sir. Okay. Thank you so much, sir.
Sir, I wish to know, previously you told us about the appellate stage trial. At that stage, again, the appellate judges has to listen or examine the whole case, in toto from the beginning, as compared to the sessions trial or from the lower court trial. So, at that stage also, is the examination chief and cross carried out again, or only on certain points
No,
or facts
no,
which have been missed by the
no,
lower
no.
sessions?
No, there would be no fresh examination in chief, no fresh cross examination. You know, the appeals are decided on the basis of evidence that was already brought on the record of the lower court.
Okay, sir.
There is one section to take care of additional evidence to be produced at appellate stage, and that is section 391 CrPC.
Okay, sir.
Section 391 CrPC says that if any material piece of evidence which could have reflected upon the merit of the case could not have been brought on record before the lower court by the party, then party can make the request to the appellate court at appellate stage to be permitted to produce that additional evidence. But
suppose some witness has been left, and that witness is very relevant to this particular case. So with the due permission of the honorable court, can we examine or cross-examine that particular witness at the appellate stage?
You will have to convince the appellate court why you failed to examine this relevant witness before the trial court when the trial was going on. Unless you are able to tell a very convincing, satisfactory reason to the appellate court, the law is ordinarily appellate court will not allow you to produce and examine this witness to fill up the lacuna, fill up this shortcoming, the deficiency in your case. You will have to tell to the appellate court very, very strong reason. What prevented you? Why you could not produce this additional evidence at trial?
But sir, it happens like if you are able to give a particular reason, is there any precedent or case laws? Like
yes, many cases I have given you. Just read this article of mine.
Okay, sir.
And also read appreciation of evidence in criminal trials and appeal.
As you said some few minutes back, in regards to some changes which students who are studying in law, those who are advocates, would like to bring some changes in and direct it to state and union ministry, further they get amended. So I think there will be some review team, right? Whether they want that changes to happen or not, and whether it is really required for citizens' welfare. So accordingly, they will take that decision, right? Because in nowadays, one thing which has been observed in case of the sections like 498 and domestic violence, women are taking undue advantages of, because of means men are getting mentally tortured and harassed. So that was my question, sir. So what are the remedies for that?
You are questioning the reasonableness of the feminine laws,
right,
relating to allegations of dowry, torture
yes,
for dowry, demand for dowry.
Yes.
Yogesh ji, so long as law like that is there, everybody is bound by that law. If tomorrow legislature thinks it proper, it should be changed, there should be some otherwise law, there should be harsher law, lenient law. It is all for the legislature. It's very difficult for me to state on behalf of the parliament or on behalf of the law minister or home minister whether they will change, bring about some changes in the law, will amend the law. Supreme Court has given some rulings. If there is an FIR against husband and against the parents and family members of the husband by wife regarding demand for dowry, torture for dowry, etc., then normally it is the husband who should be held responsible for demand and torture for dowry. The old and ailing parents, the remote relatives, mama, nana, poopa, and others should normally be not roped in, and court should take a reasonable view and grant them bail. And the same approach should also be adopted at the stage of trial and judgment.
Okay.
But you know, Domestic Violence Act is there. A lot of matrimonial disputes are going on in this country. Family courts are over flooded with the cases, and perhaps in coming years and decades, this matrimonial branch of dispute will be the biggest litigating sector in our country. It will leave all other service sector, taxation, property related disputes, everything behind. If the litigation in matrimonial matters goes on at the pace which the society is witnessing today, it's worrisome. Let us pray to the Almighty that sense prevails on everyone. Marriage is a very pious institution. It is not just to walk in and walk out. आज marriage कर लिया, कल नाराज हो गए, बाहर भाग गए marriage से. No, at least in Hindu system, marriage is not between two individuals. It is union of soul with soul. It remains inseparable for next 7 births. So this has been our culture. This has been our tradition, our civilization values. So are we adhering to our cultural and civilizational values?
So because it is seen that most of the times these disputes are getting at very long stage, and because of which the men are getting harassed. It is not that women are only harassed, but most of the women are taking undue advantage, and it reaches to some extent. I have seen some of the cases that person has been arrested because he is not able to recover the areas. So that trials are going in sometimes in magistrate court, because magistrate court have got more powers than family court. So they are directly getting those.
Yes, your voice is that of a male person who is complaining like that. Ask Swati and this organizer. They will be having a different story to tell you that it is the male dominated society that harasses the women. Therefore, they rush to the police station, they rush to the courts. So everybody has a different story to tell. It's very difficult for me to reconcile between these two opposing versions. I can only hope let there be peace, let there be harmony, let there be adjustments, let there be accommodating spirit, let there be capacity in our people to understand the values of our civilization and culture. A book of mine is there on Amazon, Hindutva and Challenges. I have dealt with marriages in Hindu system. It is a 500-page book and it is available on Amazon, Hindutva and Challenges. If you can procure it from Amazon, you can have some insight, some clarity, how it happened, what is the remedy for such maladies which our society is plaguing with. So I have given my thoughts, my views, my suggestions, how society should tackle it, how families should tackle it, how individuals should tackle it, and how institutions like parliament should tackle it, and judiciary. If you are interested in such subjects, go to this. Otherwise, so long as the law is like that, everybody will have to abide by that law. Present position is like that. All right? Right. Namaste.
Yeah.